doesn't make sense. It's not American. It's a complete violation of our Constitution, of the most foundational principle of equal justice under the law. Thank you.
Gentleman's time has expired. The gentleman from New York reserves the balance of his time. The gentleman from Florida is recognized.
I continue to reserve.
Gentleman from Florida reserves the balance of his time. Gentleman from New York is recognized.
How much time do I have left? How much time does the gentleman have left?
Gentleman from New York has 1 minute remaining. Gentleman from Florida has 2.5 minutes remaining.
And he wants to reserve now?
Gentleman is reserving.
I'll yield myself the balance of the time. Mr. Speaker, it would serve a purpose if people actually read the amendment. The amendment says none of the funds made available may be used to detain an individual who has been approved for release or transfer to a foreign country. We hear from the gentleman from Florida, these people are there for a reason. Yes, when we arrest somebody, a murder is committed, a rape is committed, we arrest somebody. But then the grand jury says, no, we're not going to indict this person. There's not enough evidence. Do we hold them in jail indefinitely, forever, even though there's no charge, even though the district attorney says we made a mistake, it's somebody else, they didn't do it? No, because maybe they'll commit a crime? That's antithetical to every notion of what the United States is about. These are 86 people who were not charged as terrorists, who we have no evidence are terrorists, and who have been judged by the military and the Joint Chiefs of Staff and the intelligence community to pose no threat to us. How, by what claim of right do we hold them in jail? The United States at this point is no better than a kidnapper if it holds in jail people whom it charges with no crime and judges say for release. Approve the amendment.
Gentleman's time has expired. The gentleman from Florida is recognized. Gentleman from Florida is recognized.
Is the gentleman prepared to yield back his time?
The gentleman's time has expired. The gentleman from New York's time has expired. The gentleman from Florida is recognized to close.
Well, Mr. Chairman, I don't think it can be said any stronger or needed to be said any more often. These detainees are bad, bad people. They hate America. They've sworn to kill Americans, and in fact they have done so on the battlefield. And that's why when they were captured, they were sent to Guantanamo. And that's where they should stay, unless the current law is abided by, and that is to be sure that the remaining Gitmo detainees who are most judged as the most dangerous will not be released or brought into the homeland where U.S. citizens could be threatened. And second, they ensure that prior to releasing Guantanamo detainees to a foreign country, a careful and deliberate assessment must be made that the detainee is not likely to re-engage in terrorist activities and the foreign government can maintain control over the individual. What's wrong with that law? It protects Americans. It protects America. And it keeps the bad guys where they need to be kept. And in this particular case, it's at Guantanamo. And, Mr. Chairman, I yield back my time.
Gentleman from Florida yields back the balance of his time. The question is on the amendment offered by the gentleman from New York. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to. Gentleman from New York is recognized. Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from New York will be postponed. It is now in order to consider Amendment Number 70, printed in House Report 113-170. For what purpose does the gentleman from New York seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment Number 70, printed in House Report Number 113-170, offered by Mr. Nadler of New York.
Pursuant to House Resolution 312, the gentleman from New York, Mr. Nadler, and a member opposed will each control 5 minutes. The chair recognizes the gentleman from New York.
Thank you, Mr. Chairman. This amendment would prohibit any funds in the bill from being used to construct or expand detention facilities at Guantanamo. The bill contains $249 million to convert temporary detention facilities into more permanent structures. But the administration wants to close Guantanamo and release or transfer the detainees. So why waste $429 million to construct facilities that will not be used? Because many in Congress want to keep the detainees in Guantanamo forever. Now, we know, 166 detainees in Guantanamo. 86 should be released immediately. The gentleman from Florida says that they're bad people. They are terrorists. They're there for a reason. No, they're not. They're there for different reasons. Some because they were handed over for bounties by rival militias or rival clans. Some because a mistake was made. Some because they're terrorists. But we make distinctions. And the gentleman says we shouldn't release them until a careful assessment has been made. Well, a careful assessment has been made. 86 of them, half of those in Guantanamo, have been cleared for release. That is to say, the Joint Chiefs of Staff and the intelligence agencies have determined that these 86 people were not terrorists and were not likely to pose a threat to the United States if released. So they're guilty of nothing. They've been tried for nothing. We don't say that people are bad people. We ought to hold them in jail indefinitely without a trial, normally, except here. So we ought to release the 86 who have been cleared for release immediately, and the others we ought to try, put on trial. There's a separate dispute whether that should be an Article III court or a military tribunal, but either way, I prefer an Article III court, but either way, put them on trial in front of a court or in front of a military tribunal and let them be tried. Perhaps most of them will be guilty and put them in jail for long periods of time. Maybe some will be innocent. That's what the justice system is about. Are we really going to say that Guantanamo is separate? Anyone who is unlucky enough to be sent there because at one time we thought maybe they were dangerous should stay there indefinitely until they die without a trial? The assessment has been made for 86 of them. They have been judged not to be guilty, not to be terrorists, and not to be a threat. That assessment has been made according to law, and these people ought to be released. The other 80 ought to be tried, and if convicted, ought to be put in prison in the United States. We have hundreds of terrorists in maximum security prisons in the United States. There's no reason a few more couldn't be put there, and we could save $249 million. Guantanamo was originally set up because it was thought by the Bush administration that if we held people in Guantanamo, they could be tried or handled without having the constitutional rights of someone in the United States. But the Supreme Court said no. The people in Guantanamo have the same rights as if they were held in the United States. So it doesn't change what will happen to them whether they're kept in prison in the United States or in Guantanamo. So let's release the 86 who ought to be released because they've been judged that they should be released by the Joint Chiefs and by the intelligence agencies. Let's try the others, and let's keep them in jail if they're judged guilty. Let's proceed with American justice notions and do ourselves proud, and let's stop wasting billions of dollars on Guantanamo. So this amendment says don't permanentize what should be and will be temporary, however temporary it is. Don't waste $249 million on making these facilities permanent. I reserve the balance of my time.
Gentleman from New York reserves the balance of his time. For all purposes, the gentleman from Florida.
Mr. Chairman, I rise in opposition to the amendment.
Gentleman from Florida is recognized for 5 minutes.
Mr. Chairman, as I read the amendment, I'm assuming that the gentleman is trying to prevent any further construction or money of that type for the Guantanamo detainees. And I can understand that because we have just recently spent a lot of money building 2 brand new prisons, air-conditioned, comfortable, and we've already spent that money, so maybe we don't need to spend any money there. But what the amendment doesn't recognize is that since 1903, we have had a presence at Guantanamo Bay, Cuba, for our own military purposes. The 4th Fleet is headquartered there and has been there for many years. Allied shipping, Allied Navy facilities, Allied forces move through Guantanamo Bay on a fairly regular basis. And I don't think we want to deny, I don't know that they have any specific requests right now for any kind of construction. But I don't think we want to deny it in the event that the Defense Department finds it important to do a construction project there. So understand, Guantanamo Bay, Cuba, has been part of the United States military facility since 1903. And so I don't think this amendment is a good amendment, because it would deny our troops, our forces, not even involved with Guantanamo detainees, the right for military construction or the right for whatever needs to be spent. And so, again, I just have to oppose this amendment, and I reserve my time.
Gentleman from Florida reserves the balance of his time. Gentleman from New York is recognized.
How much time have we left?
Gentleman from New York has 1 1/4 minute remaining. Gentleman from Florida has 2 3/4 minutes remaining.
Has how much?
2 3/4 minutes remaining.
Can you do it in 45 seconds? I'll have 30 seconds. I yield the gentleman from Virginia 45 seconds.
Gentleman from Virginia is recognized for 45 seconds.
Mr. Chairman, we just approved $260 million in the defense authorization for Guantanamo. In addition, we've approved another $186 million to construct a new temporary facility, almost $500 million in addition to what we're now spending. We spent this year alone $2,670,000 per Guantanamo detainee. 86% of them have been cleared for release. We have no reason to keep them, and yet we spend that much money. In U.S. prisons, we spend $34,000 per year. Imagine the discrepancy. And yet, we have now convicted 300 terrorists in U.S. prisons. They're being held at 98 federal prisons for a fraction of the money.
Gentleman's time has expired.
Convictions at Guantanamo that haven't been overturned.
Gentleman from Florida is recognized. Gentleman from New York reserves the balance of his time. Gentleman from Florida is recognized.
Mr. Chairman, I think the gentleman just made my case. We don't really need a lot more money for construction at Guantanamo detainees. We've already spent a lot of money there. The point is, we don't want to deny the ability of the Defense Department to provide whatever is needed for our own military forces at Guantanamo Bay, Cuba, not part of the Guantanamo detainees. And I think we've talked this one to death. We're repeating ourselves now. So in the interest of time, I'm going to yield back my time.
Gentleman from Florida yields back the balance of his time. Gentleman from New York is recognized.
Yield myself the balance of my time, Mr. Speaker.
Recognized.
Mr. Chairman, the $249 million in the budget is for expansion and permanentization of detention facilities. I have no objection to construction of military and other facilities at Guantanamo Bay. That's up. I don't know whether that makes sense or not. But the $249 million we're talking about here is for more detention facilities. That's a pure waste of money, and I'll be happy to clarify, if this amendment passes, that it should apply only to detention facilities. So if you're opposed to wasting $249 million more on detention facilities so we can spend hundreds of thousands of dollars per year per prisoner instead of $34,000 per year per prisoner in the United States, if you think that's a good idea to waste all this money, then vote against this amendment. I hope rational people who don't want to waste $250 million for permanent detention facilities will vote for this amendment. I yield back.
Gentleman's time has expired. The question is on the amendment offered by the gentleman from New York. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from New York will be postponed. It is now in order to consider Amendment Number 71, printed in House Report 113-170. For what purpose does the gentleman from Puerto Rico seek recognition?
I have an amendment at the desk.
The clerk will designate the amendment.
Amendment Number 71, printed in House Report Number 113-170, offered by Mr. Pierluisi of Puerto Rico.
Pursuant to House Resolution 312, the gentleman from Puerto Rico, Mr. Pierluisi, and a member opposed each will control 5 minutes. The chair recognizes the gentleman from Puerto Rico.
Thank you, Mr. Chairman. This budget-neutral amendment, which I offer with Mr. Young of Alaska, would enable DOD to remove unexploded ordnance from land in Culebra, Puerto Rico, which was used as a military training range for 7 decades. In 1974, Congress enacted legislation directing the Navy to cease operations in Culebra. A provision stated that the present bombardment area shall not be utilized for any purpose that would require decontamination at the expense of the United States. In 1982, the federal government conveyed land in Culebra to the government of Puerto Rico, including a 400-acre parcel within the former bombardment area. The deed provided that, in accordance with the 1974 Act, the government of Puerto Rico would not hold the federal government liable for decontamination of the land. 4 years later, in 1986, Congress enacted SARA, which amended the 1980 CERCLA law. SARA states that DOD is responsible for cleaning up contamination it caused on current and former military sites, and established the Defense Environmental Restoration Program for DOD to carry out these responsibilities. That program is funded by the bill under consideration today. SARA directed DOD to clean up former defense sites conveyed to third parties prior to 1986. These sites are eligible for federal funding, even though there were no specific authorities enabling their cleanup at the time they were decommissioned and conveyed. Nevertheless, DOD contends that the 1974 law and the 1982 deed that tracks it prohibits the use of federal funds to decontaminate the 400-acre parcel on Culebra, and that these prohibitions were not superseded by SARA. As a result of this restrictive interpretation, Culebra is the only former defense site in the nation that DOD contends it is barred by statute from decontaminating. This makes no sense. The 74 Act and the 1982 deed may have been consistent with federal policy at that time, since there was no legal framework in place that would have enabled the federal government to pay for the cleanup of the conveyed property. However, they are now squarely at odds with federal policy that has been in place for more than 25 years under SARA. Accordingly, there's no principled basis to treat Culebra differently than thousands of other former defense sites conveyed out of federal hands prior to 1986, which the federal government is obligated to decontaminate. The status quo poses a threat to human safety, since this parcel contains beaches, walkways, and campgrounds visited by over 300,000 people a year. A recent DOD report found that since 1995, there have been 70 incidents in which members of the public encountered unexploded munitions that could have caused grave harm. In fact, in March of this year, a young girl visiting Culebra Beach suffered burns after she picked up artillery shell containing white phosphorus. The FBI responded and found 6 other munitions which it detonated and removed. This potentially tragic incident underscores the need for congressional action. This amendment would ensure that the 1974 Act ceases to function as an obstacle to implementation of current federal policy as reflected in CERCLA and SARA. The amendment simply ensures that Culebra will receive the same treatment as other former defense sites in the FODS program. The U.S. citizens in Culebra sacrificed so our military could receive the training it needed. Congress, in turn, should take this small step to remove the barrier that is preventing DOD from addressing safety hazards that remain on the island. I reserve the balance of my time.
Reserves the balance of his time. The gentleman from New Jersey is recognized. For purposes, the gentleman from New Jersey recognized.
To claim time in opposition.
Gentleman from New Jersey is recognized for 5 minutes.
Certainly, I appreciate the gentleman's passion on this issue and agree that this is an important issue that needs to be addressed. As he's aware, Mr. Chairman, the Department estimates it will take multiple years and a significant investment to properly address these contaminated sites in Puerto Rico. We look forward to working with the gentleman, and we understand that he may be considering withdrawing his amendment so we could continue to work with him to address this problem, which significantly has impacted the Commonwealth.
I look forward to working with
I'd be happy to yield to the gentleman.
Gentleman yields. Gentleman is recognized from Puerto Rico.
I look forward to working with the majority, but at this point, if you allow me, I would like to yield to the gentleman from Indiana.
Be happy to yield to the ranking. Be happy to yield to the ranking. Mr.
Gentleman from New Jersey yields to the ranking member. The gentleman from Indiana is recognized.
I appreciate my friend yielding to me. I simply want to rise in support of the gentleman's amendment. The agreement that was reached, and I think some people use the agreement as an excuse to do nothing, is 40 years old, entered into in 1973. Well, they agreed to it. I graduated from law school in 1973. The world's a much different place today. People have changed, and I certainly think our environmental consciousness has improved, and our consciousness of our responsibility in this instance has improved, and do think this is an opportunity to rectify that. I serve on the Energy and Water Subcommittee of this great committee. The chairman chairs that Energy and Water Subcommittee. Unfortunately, and the formerly used defense sites were cited by the gentleman, we have over 10,000 properties, which is one of the problems I think the gentleman alludes to as far as the cost and the list we have to deal with. All the more reason, I believe, that we ought to be very assiduous and active in beginning to address these sites. So I appreciate the gentleman raising it and certainly support his position and appreciate the gentleman yielding his time to me.
Reclaiming my time.
The gentleman is recognized from New Jersey.
It was my understanding that it shared with Mr. Young that you would consider withdrawing your amendment if we gave a commitment to continue to work with you on this very important issue, which is you've dedicated so much time and effort to.
Gentleman from New Jersey reserves
yes, I'd be happy to yield to the gentleman.
Gentleman reserves his time. Gentleman is recognized from Puerto Rico.
And that's absolutely right. So I will withdraw it, but let me just say that, again, this is one property. It's only one property out of thousands of properties facing these circumstances. So I hope we can work it out. It's not going to be costly, and it makes sense to clean it up. Thank you. I yield back.
Reclaiming my time. Thank the gentleman.
Does the gentleman from New York
and I yield back the balance of my time.
Gentleman yields back. Gentleman from Puerto Rico withdraw his amendment.
I do.
The amendment is withdrawn. The committee will come to order. Will all present rise? All those in the gallery rise as well? Pursuant to the Chair's announcement of earlier today, the committee will now observe a moment of silence in memory of Officer Jacob J. Chestnut and Detective John M. Gibson. Will all present please rise for a moment of silence? It is now in order to consider amendment number 72, printed in House Report 113-170. For what purpose does the gentleman from Alabama seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 72, printed in House Report number 113-170, offered by Mr. Brooks of Alabama.
Pursuant to House Resolution 312, the gentleman from Alabama, Mr. Brooks, and a member opposed, each will control 5 minutes. The Chair recognizes the gentleman from Alabama.
Mr. Chairman, my amendment prohibits funds to implement or execute any non-treaty executive agreement with Russia regarding missile defense or to provide Russia with information about America's ballistic missile defense systems, both classified and unclassified. The reason the amendment says classified and unclassified is to prohibit the administration from declassifying missile defense technology to skirt the law. A similar amendment was passed with bipartisan support to this act last year and is included in the current continuing resolution that is funding our government during this fiscal year. Multiple news sources over the years have reported that the Obama administration may seek to share our missile defense secrets with the Russians. I am concerned these reports may be accurate. While the danger to national security is a serious concern, so is the loss of billions of dollars we have sunk into creating these exceptional technologies. The Congressional Research Service estimates the United States has spent approximately $153 billion on missile defense. Roughly 90% of that $153 billion, or $140 billion, has been spent on hit-to-kill technology. I ask the House to support this amendment to preserve America's lead in missile defense technologies, protect America's investment of billions of dollars, and ensure the viability of current and future missile defense technologies. With that, Mr. Speaker, I reserve the balance of my time.
Gentleman from Alabama reserves the balance of his time. For what purpose does the gentleman from Indiana seek recognition?
Rise to claim time in opposition to the gentleman's amendment.
The gentleman from Indiana is recognized for 5 minutes.
I have my breath taken away with the assertion that the President of the United States might give away the most intimate defense secrets of this country to Russia, and that we are debating an amendment to defense appropriations with all of the other problems we face and all the threats we face to this country, based on the assumption that the President of the United States might give away the most intimate defense secrets of this country to Russia. I would simply ask my colleagues to think about the underlying assumption based in the gentleman's amendment and vote no, and I reserve the balance of my time.
Gentleman from Indiana reserves the balance of his time. Gentleman from Alabama is recognized.
Thank you, Mr. Speaker. Reclaiming the balance of my time, there have been numerous occasions in which the media has reported that the administration is considering, as a part of negotiations or other things, divulging our sensitive hit-to-kill technology to the Russian Federation. I am thankful that my colleague across the aisle says that it takes away his breath, and I hope with that that he will support this amendment.
Will the gentleman yield?
I will yield.
New Jersey is recognized.
Thank the gentleman. We support your amendment. As you said, it is similar to what the bill carried last year and what was a provision in the Armed Services Bill. So we're supportive of it. We're obviously mindful and respectful of the rankings position, but the majority of Congress felt the way you and I do, and the committee did as well. I thank you for yielding.
Thank you.
Gentleman yields back. Gentleman reserves the balance of his time. Gentleman from Indiana is recognized.
The gentleman responds to my concern by suggesting that he has discovered the possibility that the President of the United States is going to give away the most intimate secrets this country holds to Russia through the media. I'm wondering, and I ask this question simply rhetorically, not necessarily my colleague, I wonder if there was Fox News. I wonder if he saw that on the Colbert Report recently. I wonder if that was on the Jon Stewart program. I was watching CNN, and I didn't see any report of that yesterday, although I saw that a baby was born in another country despite the world coming apart. That was the headline news. I didn't see MSNBC, and I don't know if that was it. Perhaps it was even on BBC telecast. But I'm wondering what media outlets are providing this inside information as to the deliberations of the President of the United States to give away these cherished secrets, and I would reserve the balance of my time.
Gentleman from Indiana reserves the balance of his time. Gentleman from Alabama is recognized.
Thank you, Mr. Chairman. I would submit, Mr. Chairman, that the appropriate way to gather the requested information is simply for the gentleman to Google what I have just stated. This issue arose in 2011 with numerous comments by the White House that reported in numerous outlets. By way of background, my source is not Fox News in this particular instance. But all he has to do is Google it, and he can find it. And then also, there were numerous reports in 2012 where the President indicated, in what turned out to be an open mic, that once the elections were over with, he could more freely negotiate or give away information to the Russians. Those aren't the exact words used by the President. Unfortunately, I don't have perfect recall, but it was words to those effect. And I would emphasize that this House has visited this issue previously. This has passed with bipartisan support, so I would urge this body to again, as a precautionary measure, adopt this amendment to prevent the sharing of our hit-to-kill technology with the Russian Federation to the extent that risk becomes a reality. With that, I reserve.
Gentleman from Alabama reserves the balance of his time.
I reserve and understand I have the right to close.
The gentleman is correct. Gentleman reserves. Gentleman from Alabama to close.
I yield at this point.
Gentleman reserves or yields back the balance of his time.
Yields back.
Gentleman from Indiana is recognized to close.
The gentleman indicated in query to my rhetorical question that all I have to do is Google, and I will discover the information that will lead to our knowledge that the President of the United States is considering giving away this very sensitive information. And it comes to mind when the gentleman suggests I should Google it, how many different encounters I've had with members of the public who said, I saw it on the internet. It must be true. For example, members of Congress, after serving one term, receive a full salaried pension for the rest of their lives. And members of Congress receive free health care for the rest of their lives. And members of Congress for the last 4 years in a row have received significant pay increases because they Googled it on the internet, and so they secured very specific, accurate information. Perhaps we should go to Facebook or LinkedIn or read it, or maybe we should twit each other. Again, in very serious concern, I would suggest my colleagues absolutely reject this amendment and would ask for their vote against it, and I would yield back my time.
Gentleman from Indiana yields back the balance of his time. The question is on the amendment offered by the gentleman from Alabama. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. For what purpose does the gentleman from California seek recognition?
Mr. Chairman, I have an amendment at the desk.
It is now in order to consider amendment number 73, printed in House Report 113-170. The clerk will designate the amendment.
Amendment number 73, printed in House Report number 113-170, offered by Mr. Schiff of California.
Pursuant to House Resolution 312, the gentleman from California, Mr. Schiff, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from California.
Mr. Chairman, my amendment would prohibit funding the use of force pursuant to the Authorization for Use of Military Force, or AUMF, effective on December 31st, 2014, when the last American combat troops will rotate out of Afghanistan and the responsibility for security will have passed to the Afghan people after more than 13 years of war in that country. New Year's Day 2015 should not only bring about a new relationship between the United States and Afghanistan, it should also mark the end of a conflict that was begun in our skies on that September morning and which was formalized days later when the Congress passed the AUMF. That legislation provided the President with the authority to use, quote, force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. The 2001 AUMF was never intended to authorize a war without end, and it now poorly defines those who pose a threat to our country. That authority and the funding that goes along with it should expire concurrent with the end of our combat role in Afghanistan. In addition to this amendment, I've introduced bipartisan legislation, H.R. 2324, which sunsets the AUMF effective the same date, December 31st, 2014, and calls on the administration to work with Congress together to determine what new authority, if any, is necessary to protect the country after that time. The Constitution invests the Congress with the power to declare war and the responsibility of appropriating funds to pay for it. It is our most awesome responsibility and central to our military efforts overseas. We owe it to the men and women we send into combat to properly define and authorize their mission, and my amendment will effectively give Congress the next 16 months to do so. In his recent speech at National Defense University, President Obama specifically called on Congress to work with him. Quote, "I look forward to engaging Congress and the American people in efforts to refine and ultimately repeal the AUMF's mandate," the President said. "And I will not sign any laws designed to expand this mandate further. Our systematic effort to dismantle terrorist organizations must continue, but this war, like all wars, must end." This amendment is a prudent first step towards meeting the President's challenge, a call that we must embrace not as Republicans or Democrats, but as members of Congress sworn to defend the Constitution. I urge a yes vote and reserve the balance of my time.
The gentleman from California reserves the balance of his time. For what purpose does the gentleman from Texas seek recognition?
Mr. Chairman, I claim the time in opposition.
The gentleman from Texas is recognized for 5 minutes.
Thank you, Mr. Chairman. And in some ways, I'm somewhat sympathetic to the hopes that underlie this amendment. I hope that terrorism has gone away by December 31st, 2014. I hope that Zawahiri and the others responsible for 9/11 and those who authorized, committed, or aided the terrorist attack or harbored them are all brought to justice in the next 14 months. I hope that our country and other countries around the world no longer have to worry about terrorists hiding bombs inside their clothing or inside their bodies, trying to kill as many innocent people as possible. And I hope that military and civilians who serve our nation all around the world and others in the private sector are no longer the target for suicide bombings and assassinations and the other sorts of things that we've seen since 9/11. But, Mr. Chairman, what if my hopes don't come to pass? What if the world has something else in store? What if terrorism still exists by December 31st, 2014? Well, then it seems to me that this amendment doesn't make a lot of sense. Because this amendment says no matter what, not just in Afghanistan, but anywhere around the world, we're not going to fund anything through the Department of Defense pursuant to that AUMF. Now, I've got to say, I have been and continue to be for updating that AUMF to better reflect the way that al-Qaeda has evolved over the last decade or so. Unfortunately, that has been resisted by the administration, as the gentleman just pointed out. And it is, of course, we all want this war against terrorists and other wars to end. But unfortunately, the enemy gets a vote. So for us to unilaterally say, because of the calendar, we're done, and maybe we'll pass some new authority, but maybe not, in order to protect this country, I think is dangerous. It's short-sighted. It is putting hopes above reality. So I hope my colleagues reject this. We can do better in fighting terrorists in a variety of ways, but to bury our head in the sand and say it's all going to be over on a certain date is not the way to protect this country. And I believe even it forfeits our most essential responsibilities under the Constitution. With that, I'd reserve the balance of the time.
Gentleman from Texas reserves the balance of his time. Gentleman from California is recognized.
I want to yield to my colleague from Indiana. Before I do, two quick points. No one is suggesting, of course, that terrorism is going to go away in 16 months or all of our problems will be over. But what we are saying with this amendment is that the authorization we passed that authorizes force against those who planned and authorized and committed the 9/11 attacks shouldn't be used to go after groups like al-Shabaab, which may not have even been in existence at the time of 9/11. This AUMF is now outdated. And unless we have a sunset date, we're going to continue to rely on an AUMF that no longer describes the nature of the conflict we're in. And with that, let me yield to the gentleman from Indiana.
The gentleman from Indiana is recognized.
I appreciate the gentleman yielding and rise in strong support of his amendment. The gentleman who is in opposition mentions the administration, mentions the United States Constitution. The fact is we have a constitutional responsibility, and with the passage of more than a decade and a changing world, and I would agree with the gentleman, something else may be in store. We ought to revisit that issue. We ought to exercise our constitutional congressional prerogative and have a full debate. And again, the gentleman is providing over a year and a half. And it's such a serious issue, I think even this Congress could come to grips with that type of fundamental issue and resolve the future. So I strongly support what the gentleman is doing and appreciate his amendment.
Gentleman from Indiana yields back. Gentleman from California reserves. Gentleman from Texas is recognized.
Thank you, Mr. Chairman. I'll just point out to my colleagues, this House has voted 2 years in a row to update the AUMF. So it does better reflect the way that al-Qaeda has changed. We have included the exact language used by the Obama administration and the Bush administration in court proceedings and just adopted that. The House has passed that. I don't remember how the particular gentleman voted on that, but the House has passed it. The Senate has not got along. But there has been an effort to update the language to better reflect the way that the threat has changed. But that's a far different thing from saying, okay, we're just going to make this go away and hope that in the meantime we can do something better. I think that is terribly risky, and I reserve the balance of the time.
The gentleman from Texas reserves the balance of his time. The gentleman from California is recognized.
I would only say to my colleague through the chair that this institution has proved that unless we have a deadline, we simply refuse to act. What the President has said in terms of any new authorization to use force, and this is something I agree wholeheartedly with the White House, is that he won't support a new authorization that is broader than the one that we seek to sunset. And that, I think, is a problem with some of the drafts which the majority has proposed. We don't want an expanded war. We do want an authorization that reflects the precise nature of the threat, and that threat has changed since 9/11. It no longer comes as much from the core of al-Qaeda, which has been decimated. Rather, it comes now from a group of franchises, loosely affiliated organizations that sometimes, as a product of convenience, will associate with al-Qaeda for financing or legitimacy. But it is now a far-flung terrorist challenge, and any authorization ought to reflect the changing nature of threat. And with that, I would reserve any balance of my time.
The gentleman's time has expired. The gentleman from Texas is recognized.
Mr. Chairman, how much time do I have remaining?
The gentleman from Texas has 1/4 minute.
Thank you. Mr. Chairman, bottom line is you have to read the amendment and the words that are in it. And the amendment says we can spend no money for any part of the Department of Defense pursuant to the AUMF after December 31st, 2014. Now, we can have a very interesting discussion about how the AUMF should be updated, about different authority that could take its place, but none of that is before us. What's before us is that it basically says no funding shall be used. It essentially repeals the AUMF. Now, I realize the gentleman is trying to precipitate further debate, but the fact is terrorism is not going away. This prohibits any U.S. military action, not only in Afghanistan, but anywhere in the world that al-Qaeda or its affiliates may have traveled. This stops all of that. And my point is that is too dangerous a risk in a world where there are too many people still trying to find new innovative ways to attack us and kill as many Americans as possible. We can't take that risk, and therefore I urge my colleagues to reject this amendment. Yield back the balance of the time.
The gentleman yields back. The question is on the amendment offered by the gentleman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Madam Chair, on that I would request the yeas and nays.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from California will be postponed. For what purposes? In It is now in order to consider Amendment Number 74, printed in House Report 113-170. For what purpose does the gentlewoman from California seek recognition?
Madam Speaker, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 74, printed in House Report number 113-170, offered by Ms. Speier of California.
Pursuant to House Resolution 312, the gentlewoman from California, Ms. Speier, and a member opposed, each will control 5 minutes. The chair recognizes the gentlewoman from California.
Madam Speaker, my amendment addresses a current issue that is undermining an already weakened system of justice in our military. Any JAG will tell you that it is impossible to effectively prosecute a case if the investigation was improperly handled. That is why the DoD Inspector General report released last week was so troubling. It uncovered that of the 501 investigations of sexual assault offenses they audited, all but 83 had some sort of deficiency. That means that less than 20% were completed without error. And 56 cases, 11% of the cases, had serious deficiencies. 399 of these cases had interview and post-interview deficiencies. They also found weaknesses in collecting evidence, not developing leads, and photographing the scene. This, in large part, is a result of inadequate training on how to properly investigate these complex cases. A February IG report found that criminal investigators want and need more training on conducting sexual assault investigations. For example, criminal investigators from the Air Force told the IG they wanted more training on the psychology of interviewing victims and evidence collection. One investigator said he would be, quote, in trouble, unquote, if he only relied on the training he received. That is why I'm offering this amendment that will provide an additional $10 million in funds to train investigators on how to properly investigate sexual assault-related offenses. My amendment realigns funds from the Operations and Maintenance Defense-wide account and shifts $5 million to Army Operations and Maintenance, $2.5 million to Air Force Operation and Maintenance, and $2.5 million to Navy Operations and Maintenance, which are the accounts that pay for training investigators. Ensuring that assaults are investigated properly is the first step for holding perpetrators accountable. I reserve the balance of my time.
Lady from California reserves. Who seeks recognition on the gentlewoman from California's amendment? The gentlewoman from California is recognized.
Madam Speaker, I yield such time as my distinguished colleague, Oscar, will use.
Where's she from? For what purpose does the gentleman from Florida seek recognition?
Well, Madam Chairman, I claim the time.
The gentleman is recognized for 5 minutes.
This is an issue that we can't sweep under the rug any longer. We have got to face it square on. The gentlelady's amendment helps do that. The subcommittee, when preparing this legislation, was extremely concerned about the issue, and we have included considerable amounts of money to deal with sexual predators and those who sexual assaults in the military, especially demanding that the military do a better job at enforcing the rules, the laws, to protect the rights of those who are sexually abused. So I thank the gentlelady for offering this amendment, and we do support the amendment. And I yield back my time.
The gentleman from Florida yields back the balance of his time. The gentlewoman from California is recognized.
Well, I thank the gentleman. I've got goosebumps that I actually have an amendment that my colleagues on the other side support, and I thank the gentleman. I would like to yield as much time as my good colleague would.
I appreciate the
gentleman is recognized.
And the chairman's support. The amendment does seek to target an important part of the process when prosecuting a sexual assault, the investigation of the incident. As the Congresswoman pointed out, the Inspector General found this particular part of the process lacking in terms of interviewing victims, investigating crime scenes, and notifying the Sexual Assault Response Coordinator. The funding proposed would provide the means to include special training for tactics and techniques when investigating crimes of these natures, and would join the chairman of the committee in thanking her for raising the issue and strongly support it. Thank you for yielding.
The gentlewoman from California continues.
Madam Speaker, let me just say with closing, we all now recognize 26,000 cases a year of sexual assault and rape. This is not sexual harassment, I might point out. This is unwanted sexual contact. And of those cases, only 3,000 are actually reported. The fear of reporting, the fear of reprisal is so great that very few of them, less than 20%, actually report them. And then when you report these cases, to have them improperly or inadequately investigated, that then results in a handful of actual court-martials and then even smaller, some 250 convictions out of some 3,000 that are reported, suggests that we have a lot of work to do. I thank my colleagues for the support, and I yield back.
The gentlelady from California yields back. The question is on the amendment offered by the gentlewoman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. It is now in order to consider Amendment Number 75, printed in House Report 113-170. For what purpose does the gentlewoman from California seek recognition?
Actually, Madam Speaker, the amendment we just took up, and it was my fault, was actually Amendment Number 75. No? No?
If they did 75, you can't offer 74.
I see. All right. Madam Speaker, I do have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 75, printed in House Report number 113-170, offered by Ms. Speier of California.
Pursuant to House Resolution 312, the gentlewoman from California, Ms. Speier, and a member opposed, each will control 5 minutes. The chair recognizes the gentlewoman from California.
Thank you, Madam Speaker. Since I began working on this issue of military sexual assault 3 years ago, I've had the opportunity to speak to over 100 courageous survivors of rape. With each of their experiences, there is a unique nature to them, but many of these survivors that decided to report these crimes have had a very similar experience after they reported. They were retaliated against, ostracized, and involuntarily separated from the military on the grounds of a personality or adjustment disorder. Mental health diagnoses are grossly misused to administratively discharge or retaliate against survivors of sexual assault and other service members. Since 2001, the military has discharged more than 31,000 service members on the grounds that they were subject to a personality disorder. A GAO investigation found that in 22 to 60% of the time, personality disorders were either not diagnosed by a trained psychiatrist or psychologist, or there was undue command influence. This pattern has become a potent lesson to service members that are assaulted. Report and get kicked out of the military with a personality disorder diagnosis. This designation amounts to a scarlet letter pinned where their medals should be and follows them for the rest of their lives. These service members are re-victimized every time they apply for a job and submit their D-214s. It also makes it virtually impossible to retain a security clearance. My amendment aims to address this clear pattern of retaliation against victims who report a crime of rape or sexual assault. The amendment provides funds to correct their service records and provide them with the benefits they have earned. My amendment realigns $65 million within the Operations and Maintenance Defense-wide account to dedicate these funds to identifying and correct the service records service members who were summarily discharged from the military following reports of sexual assault. This amendment requires the Defense Department to review all separations of individuals that made an unrestricted report of sexual assault and determine if they were discharged and on what grounds, including personality and adjustment disorders. My amendment will also direct the Secretary of Defense to correct their records of service, to right this wrong, and provide them with any compensation and services they weren't eligible to receive as a consequence of this error. This is the very least we can do for these brave survivors. It is the first step in addressing the systemic re-victimization of courageous men and women who were brave enough to come forward. I reserve the balance of my time.
The gentlewoman reserves the balance of her time. For what purpose does the gentleman from Florida seek recognition?
Claim the time.
The gentleman is recognized for 5 minutes.
Again, Madam Chairman, this is a good amendment. Those who are subject to sexual assaults, sexual attacks, and who have been separated from the military on grounds of a disorder need to have their records corrected. If information indicates that that should be done. Sexual assault victims have already suffered a great deal. They deserve to have their military records accurately reflect their military service. And those victims who were improperly discharged on the grounds of a personality disorder deserve to have those records corrected. This bill already, we do support the amendment. This bill already provides substantial funding to provide these services. And I notice a very distinguished gentleman rising. Would you like me to yield?
Gentlemen, I appreciate the gentleman yielding and want to associate myself with his kind remarks and indicate my support for the amendment as well, and appreciate very much the gentleman yielding and appreciate the gentlewoman for offering the amendment.
Needless to say, we support this amendment. We have already robustly financed sexual assault programs. We fully fund the President's request for sexual assault prevention and response programs at the service level and at the Department of Defense Sexual Assault Prevention and Response Program Office. And I would like to emphasize prevention. If we can prevent these sexual assaults, then the other problems go away. And so it's important that we do pay attention to prevention. In addition, our bill provides $25 million to the Department and the services, including the Guard and Reserve, to implement a sexual assault special victims program, such as the Air Force Special Victims Counsel Program, to provide all victims with specially trained legal assistance throughout the investigation and prosecution process. Fair play, and that's important. We also support a number of policy changes that we're including the FY 2014 National Defense Authorization Act. I think our bill goes a long way on this issue, and this amendment goes even further, and so we enthusiastically support it. And I yield back my time.
The gentleman from Florida yields back the balance of his time. The gentlelady from California is recognized.
Madam Speaker, thank you, and I thank the chairman and the ranking member for their unanimous support of this effort and this particular amendment. Let me just close by saying if the GAO says 20 to 60% of these personality disorder designations are either done improperly or done with undue influence, certainly those who have been victimized deserve to be able to have that designation erased from their DD-214 forms so that they're not in a position of having to then, in the civilian world, have to explain why they have this designation on their discharge papers. And I yield back.
The gentlelady from California yields back the balance of her time. The question is on the amendment offered by the gentlewoman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. It is now in order to consider amendment number 84, printed in House Report 113-170. It is now in order to consider Amendment Number 97, printed in House Report 113-170. For what purpose does the gentleman from Florida seek recognition?
Thank you, Madam Chair. This amendment should serve as a reminder.
Does the gentleman have an amendment at the desk?
Yes, please read the amendment.
The clerk will designate the amendment.
Amendment number 97, printed in House Report number 113-170, offered by Mr. Radel of Florida.
Pursuant to House Resolution 312, the gentleman from Florida, Mr. Radel, and a member opposed, each will control 10 minutes. The chair recognizes the gentleman from Florida.
Thank you, Madam